It is a common thing for Americans to want to spend time with their families. That is also true for immigrants. We have previously talked about marriage-based petitions and parent-child petitions. But did you know that a U.S. citizen can apply for a green card on behalf of his or her sibling? You can petition for your brother or sister to be a green card holder in the United States. Hi, I'm Andre Major, immigration attorney and an immigrant myself. In today's episode, I will guide you on how to petition for your sibling so he or she can get their green card. Before I begin, please click on the subscribe button and hit the notification bell for you to get updates on our new immigration content. Also, feel free to leave a comment below on your thoughts or ideas about today's topic, and please check out our other videos. Let's get to it. Who can petition for siblings? First, you must be a U.S. citizen. Those who are permanent residents are not eligible to apply for their siblings. You will have to wait until you become a citizen, which can take 5 years or more in some cases. Secondly, you must be at least 21 years old and must demonstrate that you are able to financially support your siblings and that they're not going to rely on U.S. government assistance. Now, what are the disadvantages of petitioning for your siblings? Well, the number of visas issued under this category is limited, and it will take years for your siblings to get their green card. This type of petition is also not on the top of the priority list, being classified as the family fourth preference or the lowest level. The waiting time can be longer, 10 years, 15 years, 25 years. It really depends on when you file and what country your sibling was born in. But for more information on how to read the visa bulletin, see our video on the subject. If you're unsure of your decision, you can consult an immigration attorney to discuss the immigration route that you could take. Sometimes there are other options. For example, applying for your parents and then your parents applying for your siblings. That can frequently be a lot faster. Or there might be a completely different alternative altogether. Now, let's talk about who is considered a brother or sister under immigration law. First is a legitimated brother or sister. What do we mean by that? Basically, these are your siblings whose married mother and father is the same to yours. To demonstrate your relationship, you must show your birth certificates, which should indicate the same mother and father for the two of you. Second is a half-brother or half-sister. This refers to your sibling who either have the same mother or the same father as you, but not both. Similarly, you'll have to provide a birth certificate to establish your relationship with your sibling. This should show the name of your mother or father that you have in common with your sibling. Third is a stepbrother or stepsister. When one of your parents marries someone else and that person has a child from a prior relationship, that child is designated as your stepbrother or stepsister. To demonstrate the relationship, you must provide you and your siblings' birth certificates, the marriage certificate of your mother or father to the step-parent, and any document that serves as proof that any prior marriage was terminated through death, divorce, or annulment. Take note, however, that your mother or father and step-parent must have been married before your 18th birthday to be eligible for this arrangement. Last is an adopted brother or adopted sister. As the name suggests, this refers to your siblings who were adopted by your parents in line with the laws of the state or nation where they reside. Under this classification, you may petition for your adopted brother or sister if the adoption process and decree were completed before your adopted sibling's 16th birthday. Now, it's not your birthday, it's their birthday. So the adoption has to be completed before they turn 16. To establish your relationship with your adopted sibling, you must provide, together with your petition, the adoption decree, and you and your siblings' birth certificates indicating the same parents. Now that we have defined who are considered a brother or sister, let's discuss how to petition for your brother or sister. First, prepare Form I-130 and supporting documents. It's important to gather the supporting documents in filing for a visa petition. You must be organized, such as using a checklist, in order to prevent filing an incomplete visa petition, which can result in the visa petition being delayed. The following are the needed documents you need to gather. Form I-130 petition for alien relative, your birth certificate of your immigrating sibling, a document proving your citizenship in the U.S., such as current U.S. passport, U.S. birth certificate, consular report of birth abroad, naturalization certificate, or certificate of citizenship. If you are providing for a step-sibling, half-sibling, or adopted sibling, you must also provide the following documents. For adopted siblings, you need the adoption decree of your adopted siblings. And remember, it has to be completed before your adopted sibling turns 16. For step-siblings, present the marriage certificate of your parent and step-parent. Additionally, you have to provide any documents proving your parents' prior marriages were legally terminated. Remember, if you or your siblings' names are different from those that appear on the birth certificate, you must provide additional documents that would explain the change in name. For example, marriage certificate, divorce decree, adoption decree, court documents, and so on. Step 2, file your petition. After you've completed all the required paperwork and forms, the following step is to file your visa petition. You can file the visa petition online by creating an account at uscis.gov or by mailing it to the appropriate USCIS lockbox for your region. You will receive a receipt notification once the USA has received your application and confirmed that everything is in order. Take note, if you relocate while the process is still ongoing, you have to fill out Form AR11, Alien Change of Address, with USCIS. You can also do this online at the USCIS website. After the USCIS approves your I-130 petition, your sibling will be assigned a priority date. We'll assist you and your sibling in tracking the status of your immigration application. You can keep track of it by using the State Department's Visa Bulletin. Again, to learn how to read the Visa Bulletin, take a look at a video that we've previously created. But before we continue, go ahead and click the thumbs up icon down below and hit the notification bell to keep yourself updated about all our new immigration-related content, because we do create content frequently. Let's get back to the next step. Step 3, adjustment of status or consular processing. Once your siblings, once the I-130 is approved and the priority date becomes current, they can apply for adjustment of status or for their green card through the U.S. consulate if they're overseas. Most of the time, your siblings will have to undergo a consular processing, meaning applying at a U.S. consulate closest to them. They must communicate and attend the visa interview at that consulate or embassy. If your sibling is already in the United States, they may be able to adjust their status here, but it is really unlikely and is really rare. You need 245I eligibility, or you need some kind of waiver. But if you're eligible for those waivers, you usually have better options than a sibling application. However, again, it does happen, particularly in the 245I scenario. But in most cases, they may not be eligible to adjust in the United States, especially if they spent some time in the U.S. illegally. But there are some cases where adjustment status still pushes through. For the majority of people, they are going to need a consular interview. If you're not sure which one applies to you, speak to an experienced immigration attorney to help guide you through the process. Don't be like the family that I just spoke to. They waited for 2 years. They got denied their adjustment of status because his spouse was a green card holder, not a U.S. citizen, and not eligible to adjust. So it's not the same scenario, but don't let something like that happen to you. If you're not sure, find out, seek help. Once everything is in order, your sibling will be granted the immigration visa to enter the United States. And now that we know the application process, you may wonder, well, what if my petition is denied? Can I still file an appeal? The answer to that is, it depends. It's stated in the denial letter whether you can or can't appeal. But just because you can appeal doesn't mean you always should. Again, if you get a denial, I strongly encourage you to speak to an attorney before just filing an appeal. Appeal takes a really long time. Sometimes there are better alternatives like a motion to reopen or a motion to reconsider. Seek help. And that summarizes who you can petition as a sibling and how to file for the petition. The process may seem intimidating and lengthy, but remember, all of your hard work, time, and resources will be rewarded once you're reunited with your sibling. If you want to discuss your case or you need help in application, feel free to leave a comment below or visit our website on thismechalalaw.com where you can schedule an appointment. We'll let you know if and how we can help. And if you find this video informative, please like and share it with your friends who are also applying or thinking about getting a green card. If you have any ideas for future videos, let us know. Until next time, stay healthy, be safe.